tend to see it as raw as this.
Good evening and welcome.
And Judge Wyndham's going to make a decision on that next week. But let's talk about it. Joining me right now is Deputy Public Defender from LA County, Philip Dube, as well as long crime legal analyst Dan Shore. Good morning, gentlemen. It's good to see both of you. Philip, I'll start with you. I've never seen an argument like this before, that somebody, a defendant, wants to take the stand. It is his right to take the stand. But that defendant is so sick that they cannot take the stand, that the stress, what it takes to actually subject yourself to cross-examination and be on the stand for hours and hours and hours, that is just too much. It might kill the person. What is the court going to do here?
The court's going to look at very well-established case law in California and read it in harmony with the United States and the California state constitutions. And that is, yes, every accused, every defendant has the right to be physically and mentally present in the courtroom. He is physically present, although frail and, haggard, for lack of a better term, but he is mentally present as well. There has been no inability on his part to communicate. Listen, his voice does sound sort of hoarse and perhaps even a bit winded, and it's obvious that life and his frailties are taking a toll on him. But there is absolutely no sign of cognitive dysfunction. And short of, losing consciousness, collapsing, or semi-consciousness, or lack of alertness, he's mentally competent. What the court can do is simply accommodate him, meaning if he takes a stand, in 30 minutes or 45 minutes, he's just simply too tired or he's losing his voice, you take a break. And then you resume after he has recovered. If need be, you put it over a day and you allow him to recover. That's what the heart of the case law is about, making reasonable accommodations for people who have health problems.
Okay, so Philip, when you listen to that, doesn't it also affect Durst's ability to provide the kind of testimony he wants to provide? Him taking the stand is going to look very different than when he took the stand in his Galveston trial. And is that fair to him at this point?
100%. Right now, his lawyer has not declared a doubt about his mental competency and his cognition. And I'm sure the reason why is that if you do that, you're going to halt the proceedings. He's going to be held in a locked setting until he is seen by doctors. And let's assume he is found mentally incompetent. He's not getting out. He will go to a locked state hospital until he is restored to competency. Dick DeGuerin ain't going to do that. The court is in a very tough position right now because, first of all, it cannot restore hearing to the deaf, it cannot restore vision to the blind, and it cannot restore speech to the mute. However, what it can do is accommodate those disabilities. Jesse, over the years, I've had clients with many physical problems. I've had clients brought into court who have suffered strokes, and they are in court on a gurney, but yet they're sharp as a tack and they understand what's going on.
We're going to talk more about Robert Durst and what's going to happen next week, so stay with us here on Law and Crime. We'll be right back right after this.